Morning for you.
SJC-10095, Commonwealth v. Quilly Merle Spray II.
Thank you, Fran. Good morning. Thank you.
All right, let's proceed.
Good morning, Your Honors. May it please the Court, my name is Ken Seeger. I am here on behalf of Quilly Merle Spray, the defendant. Your Honors, the issue that I would like to discuss this morning concerns Mr. Spray's claim of ineffective assistance of counsel at his trial for first-degree murder. And I would like to summarize Mr. Spray's claim to the Court. And to summarize,
Can I just ask you,
Yes.
because there's the briefs from 2008 raising the appellate issues relating to the first motion for new trial, and
that is correct, Your Honor. At this time, I do not wish to argue those issues. I'd be willing to submit on the briefs for those issues
okay,
and focus on the second Rule 30 motion.
okay.
And Your Honors, just to summarize the claim, if trial counsel had conducted a proper pretrial investigation,
You say it was a perfunctory thing, that he just went through the motions, right?
well, she did a very perfunctory pretrial investigation, investigated a mental health report that might have been out there someplace, or mental health records that might have been out there. She didn't find any, and she essentially just gave up on trying to find anything more.
Did she talk with the family members? Wasn't it, did she talk with the mother, and didn't she try to talk with the other family members and they wouldn't talk with her?
She spoke with the mother. The mother gave her some information relating to some mental health treatment in Oklahoma in the past.
When he was a teenager?
When he was a teenager.
How old was he at the time of the events?
He was about 31 years old at the time of the incident.
Okay, and do we have those records? Were they ever produced from Oklahoma?
Some
from when he
records
was a
were
teenager?
produced. The records when he was a teenager were never produced.
So they weren't in connection with the motion for new trial? They weren't shown to be available?
That is correct, Your Honor. There is a record that was introduced as an exhibit at the motion for a new trial, and that's a 1997 record from a hospital visit at a facility in Oklahoma, and that's included in the record appendix. And in that record, Your Honor, he was diagnosed with amphetamine-induced psychotic disorder.
Had his mother told the defense counsel about that hospitalization?
She did not.
So nobody in the family and the defendant didn't inform her he had been hospitalized for anything having to do with drug-related stuff, other than when he was a teenager?
That's correct, Your Honor. So there was information that he was a drug abuser in the past, but they did not provide trial counsel with that information. That is true. And what I suggest, Your Honor, is that if counsel had requested a psychiatric evaluation, and there are certain factors which I've noted in the reply brief and then prior counsel noted in the primary brief, that should have placed counsel on notice to the absolute necessity of a psychiatric evaluation. And a few of those factors would be, first of all, the overwhelming evidence against the defendant, which trial counsel admitted at the Rule 30 motion was overwhelming. So, for example, 3 witnesses who testified that they saw the defendant commit the assault.
These were his family members
These were his family
who
members.
were cross-examined by counsel as to their having been basically spaced out on drugs.
That's correct, Your Honor. And that's also interesting to note that when she cross-examined the family members, she brought out the fact that they themselves were abusers of methamphetamine, which makes the user aggressive and violent. So there was some knowledge on counsel's part that methamphetamine abuse leads to aggressive behavior.
Did she have any reason to know that her client had ever used methamphetamines?
Well, yes, she did. He told her that, but he told her of his methamphetamine use, I believe it was the day prior to the incident and in the past, not on the day of the incident.
So he told her he had used meth in the recent past.
That is correct, yes. So I would suggest, Your Honor, that a few of these factors that I've described in the reply brief as red flags, as it were, the strong evidence against Mr. Spray that should have made her realize that the defense that she raised at trial was not the reasonable one. And I would, I'm sorry.
How do we come away from this case? What's the, is there a requirement now that any defendant who has taken methamphetamines within a week of the incident should now be submit to a mental examination, otherwise counsel's ineffective?
No, not at all, Your Honor, and I wouldn't suggest that. But there are certain factors that should have put her on notice in this particular case. So not only the evidence against Mr. Spray, but I would also suggest the senseless and motiveless nature of the crime.
Well, I mean, when you say senseless and motiveless, maybe nobody knew what the motive was or knew what the reason was.
Correct. There is no suggestion on this record at the trial of any ill will whatsoever between the defendant and the woman who was the victim in the case.
But that doesn't mean there wasn't a motive.
There was no motive presented at trial. This was a senseless...
So if there's no motive for a killing and a defendant has taken drugs, the defendant should be subjected to a mental health exam.
Well, perhaps not in every single situation, Your Honor. I think these facts need to be looked at, on a case-by-case basis. But looking at this picture together, there are a number of factors. So you don't have a motive. You don't have any provoking factors. There's no reason that was presented for the defendant to attack this woman. You have very strong evidence.
He said he told his lawyer he didn't attack her. And he told his lawyer he was not under the influence of drugs. He hadn't taken any drugs that day. And when the police, asked him what had happened, he described that he had seen this woman on the ground, and he walked outside of the building because he didn't want to walk over the tiles they had just set, and he went over to see what was happening, see what was going on.
And in the immediate aftermath of this incident, his demeanor is very interesting because the other witnesses are acting as they should. They're nearly hysterical. The defendant, on the other hand, is described as being detached, disassociated, strangely silent. There are a number of factors that need to be looked at in conjunction with each other that should have alerted counsel at the very least. And of course, he denied it. He said he didn't do it. He didn't know who did it. He didn't point his finger at anyone else.
So is the lawyer now, what if the lawyer had proposed a mental health examination and the defendant said, "You're crazy. There's nothing wrong with me. I'm not going to submit to a mental health examination. I've told you I didn't do it. You don't trust me? You're my lawyer. You're supposed to be acting on my behalf." What's the lawyer to do?
Well, she would need to request a psychiatric evaluation. That didn't happen in this case. There was simply no request for one. She didn't pursue it at all. She looked for some records, came up short. He said he didn't do it, and she began to create an alternative defense, which I suggest was not a viable and reasonable defense. If Mr. Spray had been able to present a defense of criminal responsibility, it would have been a more viable and effective defense than the one that was presented.
But what he was saying was, I didn't do it, somebody else did. And they're trying to, my family who's saying they saw me do it is trying to frame me.
But from the point of view of the attorney, she has to look at these factors, the evidence against him, his demeanor, the motiveless nature of this, some suggestion of mental health treatment in the past, methamphetamine use, and she needs to put two and two together and say, of course he did this. There's no reason for it. Even though he's denying it, he doesn't know who did it. It doesn't make sense. There's got to be some kind of mental problem, and that necessitates a psychiatric evaluation.
Because she interviewed her client 12 times, and during none of those consultations that it appeared to her that there was anything wrong with this guy. Was there any evidence that she talked to people at the jail? Had he been treated by doctors at the jail where he was being held?
There's no evidence of that, Your Honor, but Commonwealth versus Ribeiro says that counsel's evaluation, yes, she sat down with him 12 times. Her evaluation cannot substitute for the evaluation of a court-appointed psychiatrist.
Yeah, but you're saying she has to know something to get the ball rolling. And my question to you is where she's met with him 12 times, and there's no indication from anybody at the House of Correction that he's suffering from a mental illness. She followed through on the little lead that she had.
If she had requested a psychiatric evaluation back in 2001, after this incident before trial, I suggest that it would have looked similar to the one that the court now has. And Dr. Presskreischer has provided the opinion in her report that he suffered from methamphetamine-induced psychosis, and that he suffered from...
Likely, right? I mean, she's not even giving that opinion to a reasonable degree of medical certainty.
That is her opinion to a reasonable degree of
Is it?
medical certainty. As far as I know from this record, it is.
Okay.
And that he suffered from methamphetamine-induced psychosis. And
Was that a diagnosis even available at the time of the trial?
actually, Your Honor, there's some confusion about that at the Rule 30 motion, and it was. She had testified at the Rule 30 motion that it was not included in the DSM, but then she clarified that, and it's included in the record appendix that amphetamine-induced psychotic disorders was included in the DSM that was available in 2000. And what that means is that counsel, had she requested a psychiatric evaluation, this was a disorder that was known within the scientific community, the psychiatric community. It was known within the mainstream. It was established, and it's there in black and white in the DSM, and a psychiatrist would have known that. So, Your Honor, it's the number of factors, it's the full picture. And of course, in not every single case when a person is on meth there are many different situations that can occur. But in this particular situation, you have a crime that apparently makes no sense. It's not like Commonwealth versus Walker, which involved a fight in a bar room, and the defense counsel was able to come up with a self-defense claim. There's no reason for this to have happened, but the court now knows and now has a better explanation of what happened, which is that he was suffering from a psychotic disorder, and he acted out in accordance with that. And Dr. Presskreischer and as well Dr. Eric Fine, who was a psychiatrist who was deposed, he was hired by the plaintiffs in a civil lawsuit, and he provided essentially the same opinion. Although he never examined the defendant, he discusses this disorder, which is known in the mainstream and can cause a person, after prolonged effects of methamphetamine, it damages the brain. It causes hallucinations, delusions, and a person can act out in accordance with what he perceives in his psychotic state to be self-defense. And a person, and this is what Dr. Fine testified to at the deposition, a person can look at the defendant the wrong way, and the defendant can act out a delusion and believe that he needs to act in self-defense. Now, I would suggest to the court that when one takes the defense...
But he never said that. He never said that she threatened me.
He never said that.
So, I mean, but
says it never
the whole premise of what you're saying is a person will hallucinate that somebody was threatening me. Immediately afterward, first of all, he's laying tiles, which requires some degree of intricate movement and concentration. And then he walks over and kills her and denies having done it, and he remembers the path that he took to get over to her and the path that he took to return, and he never says that she threatened me or she did anything towards me.
That's correct. We're talking about a
But
person...
where's the hallucination?
We're talking about a person who's psychotic.
But all I'm saying is, where's the evidence of a hallucination?
The evidence, there's no evidence of a hallucination, but there's evidence at the Rule 30 hearing after being evaluated by a psychologist, that he had this disorder, which includes hallucinations. The methamphetamine creates this psychosis, and this is in the mainstream community, which creates hallucinations and delusions.
Yeah, but that's all well in an from a theoretical point of view, I can accept what you're saying. But where is the evidence of a hallucination upon, that was either symptomatic or endemic or there's no manifestation of a hallucination in this case. He never told anybody.
Maybe I could follow up on that. If there was something like that, even that he had told his attorney, that might have provided some basis for further inquiry on part of counsel?
Sorry, Your Honor.
So, listening and reading the briefs and listening to your argument, I keep waiting to actually find more than you've provided for that hook that would enable us to say, as you ask, that this attorney was on notice and should have done much more than she did to ferret out that, let's assume that the psychosis exists, that this is, in fact, something that he was troubled by. He had this diagnosis of methamphetamine, psychotic, whatever it was that caused this. So what was it? I mean, if it had been him saying, I thought she threatened me, or anything, even inkling of it that would have raised from the description to his attorney of his participation that this was...
Really what it is, Your Honor, it's looking at a full picture of what happened at this incident, and it's looking at not only the very strong evidence against him from the witnesses, the forensic evidence, and so on, the admission to the police later on, but it's looking at what I maintain is a senseless crime that apparently has no motive, no provoking factor that causes him, that we know of, to cause him to stab this woman. It's looking at that. It's looking at his strange demeanor after the incident. And it's looking at all these factors. And it's an attorney whose own judgment cannot replace that of a psychiatrist, which is what Commonwealth versus Roberio says. So, of course, he denies it, but she needs to look at this full picture. And even though he's denying it, his denials and saying, I didn't do it, it must have been somebody else, I don't know who was, doesn't make a lot of sense.
He testified at trial, did he not?
He testified at trial. So she has to look at this full picture, and she has to see the necessity of requesting, at the very least, requesting a psychiatric evaluation, which then would, and as I suggest, if that had been done, because this disorder was well known, and it was in the mainstream documented in the DSM back in 2000, if that had happened prior to trial, I suggest that the report that the psychologist came up with back then would have looked the same or similar to the one that the court now has. And Roberio says that, and this is part of the problem, that counsel can sit down with her clients and ask questions, but those are not the same questions that a psychiatrist is going to ask. The psychiatrist is going to dig much deeper into any possible mental health issues, is going to dig a little bit deeper than just saying, okay, you're denying it, that's it, because the denial itself, as Dr. Press-Kreischer testified, the denial itself can be a symptom of mental illness. So a psychiatrist has to go in there, and of course it's not in every situation, but an attorney has to use his or her own judgment and look at a case and put two and two together.
Trials are pretty stressful, and part of what, as I understand it, he had been through a lot of stress in the days leading up to this. So how did he do at trial? Was there any evidence of this psychosis playing itself out right up near the trial, or when he testified during the trial?
There was not. There was some testimony from the doctor when she interviewed him at the prison that he was exhibiting what she believed, in her experience, were continued signs of psychosis. And of course, defense counsel's judgment cannot replace that. And we know that from the case law.
Could you remind us just what the counsel was told about the extent of his meth use?
that he had been using methamphetamine from the time he was 14 years old, that he used it sometimes on a daily basis throughout his life, that he used it was either 1 or 2 days prior to the incident itself. And she knew this, and I should point out, and I didn't get into this in the reply brief, that when she cross-examined the witnesses, she apparently knew that methamphetamine can cause violent behavior, aggressive behavior. So there was some knowledge there about the effects of this. Your Honors, I see that my time is expired. Are there any further questions?
Thank you, sir.
Thank you very much, Your Honors.
Good morning, Your Honors. May it please the Court, Donna Marie Heron, Assistant District Attorney representing the Commonwealth. The motion judge here properly denied the defendant's second motion for new trial, where the defense counsel was not put on notice, as Ribeiro and Walker and all the case say. There has to be something to put the defense counsel on notice. And in Ribeiro, it was the victim's family, after he's arrested, telling defense counsel the police have gotten him mental health. He has mental health issues. The jail has recommended he get mental health evaluations, and defense counsel did nothing to follow up on that and said in his talking to the defendant, he didn't think he had anything wrong with him and didn't pursue that. And this court found the fact that defense counsel didn't even bother to look into what the parents had told them at the time of trial was ineffective. In this case, you have a defense counsel who's told by a mother that the defendant some 20 years ago was using drugs and received drug treatment and some mental health treatment at a facility. Defense counsel calls that facility. They know they don't have the defendant listed. They don't have his records anymore. I want to clarify the record for a bit. She talked to numerous family members. She said she talked to his mother, she talked to his brother, she talked to his ex-wife, she talked to his cousin. She said she talked to other people, but she couldn't exactly remember who they were. And then the sister-in-law was the one that refused to talk to her. She also, I would suggest that there was nothing else to put this defense counsel on notice, particularly where a defendant is repeatedly saying he's innocent, saying he didn't do this.
But what about his, counsel was just saying that the defendant told her that he had used methamphetamines since he was a teenager throughout his life.
He said, yes, throughout his life, sometimes a lot, sometimes not. And he said particularly when he had to take over his father's business, he stopped using because he wanted to be able to do the work, do the talent work. And he did testify to that he weaned down his drug use. Then he was actually, I think the testimony at trial was angry with his brother and sister-in-law because when they went to go do the job, he found out that they were in New Orleans or some other place grabbing drugs, and that angered him. So he went up, and his testimony at trial was that he spent the night at his car, and then he did the tile work, and that was Friday, I believe. And then they stayed at a night hotel. He did not tell her, I don't believe at trial, he testified he did drugs that night. He said his brother and sister-in-law did. And then that next morning, they go do the work, and he has a detailed statement, which he gives to the police an hour and a half after being arrested, or within 2 hours of being arrested, of his exact movements of that day. And I would suggest if this court looks at Commonwealth v. Walker, I would say it's striking to this case, and that is at 443 Mass 213, and it's 2005 from this court. And I think the parallels between that case and this case are very striking. I would like to get into the defendant here keeps claiming there was overwhelming evidence, and there was, but what I want to point out to this court, which I know he's not arguing today, but in the first motion for new trial, they're arguing that without the brother and sister-in-law's testimony, there's barely any evidence, and it questions the justice of his verdict, so I find it somewhat how you reconcile the two motions for new trials that are before you, where one says there was, without the two testimony of the brother and sister-in-law, there would barely, I think, be any evidence. And then now in his second motion for new trial, he's saying, oh, there's so much overwhelming evidence that it should have put counsel on notice. And I also want to point out that I believe counsel did an excellent job in her theory of defense. Just because it didn't work didn't mean it was ineffective or didn't mean it gives him a new trial. She said that the sister-in-law, and I think she worked with the evidence, did a very good theory that it was the sister-in-law who actually killed the victim, that she was allowed to change her clothes. And with the wounds the victim sustained, it would have made sense that a lot more blood would have gotten on, that the blood the defendant had on him reconciled with his story, that he bent over to check up on her, that Monica was the one that was screaming and yelling at the scene to try to divert attention from herself. And I believe she put forward a good defense. It just, in the end of the day, did not was successful for the defendant, and this court has repeatedly stated that that in itself does not, just because her defense did not end in acquittal does not enable the defendant for a new trial.
But what do you say, you know, as to each of these factors taken alone, it wouldn't be enough. I think that, but counsel's really arguing it's the whole sort of gestalt, you know, when you have all of this stuff staring you in the face, you know, long-time meth use, a somewhat inexplicable crime, motiveless crime, his affectless behavior afterwards, you know, all of the things that have been mentioned here, you put them together, and that's enough to put counsel on notice.
This court in Walker said that wasn't enough to put counsel on notice, first of all, and I would like to get to some of those issues with the detach at the scene. I know defense counsel on direct testified that he was almost catatonic at the scene, but then when cross-examined, she then admitted, no, he wasn't catatonic, that he was just very quiet, and I would strongly suggest the court to look at the record. I think it's the defendant's record at 200 through, I think it's 215, which includes all the police records, and if you read there, in no way does the police describe him as catatonic, unusually quiet. What they do state is the three other family members were the ones yelling and screaming, saying he did it, particularly the sister-in-law. The brother is screaming at the defendant, and I think the cousin is somewhat yelling, but not much, as compared to the defendant who wasn't saying anything. And that's what they point out. I don't think it's catatonic or unusually quiet. And for the motiveless part of the crime, I think defense counsel was able to utilize that in her strategy by arguing he had no motive to kill her. Monica did have a motive.
What was Monica's motive?
She was a drug user. She got in through the testimony of the brother and her that she becomes very violent when she uses, that they have been repeatedly using drugs on this trip. That's why they were late coming to do the work, and that her drug use caused her to get anger and fits, and that maybe she killed him out of one of these drug-angered fits.
The woman who was killed was the manager of the store that was
Yes.
being built?
She was, yes, and she was taking applications in the back while they were tiling the front of the restaurant.
Was there any indication or any evidence of dealings that were unpleasant or adverse or anything between that woman and any of the members of the family?
No, no one testified. They said she kept to herself in the back. They stayed in front. I think the defendant himself testified that he offered to give her a heater because she was cold. I'd also like to point out that all the workers that testified during the trial all did not state the defendant was in a psychosis. They all testified he acted normally. And in cross-examination of the expert, she admitted she didn't read any of those testimony during trial of all the workers, and I believe there was 3 or 4 of them that testified to interactions with the defendant that day, that none of them saw anything that was unusual or would alert them to any issues with the defendant. He was acting.
Did she acknowledge that would make a difference in her opinion?
No, she didn't, but then she also admitted that she has never seen, it's the spontaneous psychosis, meth-induced psychosis. She said she's never seen that. The episodes of the defendant in the past were always when he took methamphetamine, including the, which he attached to his record appendix, the hospital records was right in correlation of when he takes methamphetamine. She admits she's never seen someone have a spontaneous, which was her diagnosis here, which I would suggest Walker looks into that too, the chance of, and the second prong of Safarian, the likelihood of success or deprive them on otherwise valid defense.
Was there anything either in the expert testimony or in the literature that might have been provided to the judge that indicated how long a spontaneous episode is expected to last?
I don't recall she testified to that. In the literature, I'm not quite sure of that answer, of how long they can last. I think she said it varies, if I recall, but I don't remember. But if I suggest you look at his behavior right after the murder, he can give a detailed description of what he did that day, of how they went to get lunch, how Monica got ham sandwiches, and then they brought him back and they ate. He asked her if she was cold, the victim. She said she wasn't. He then began lying tile. He then looked up and saw she was on the ground. He details the route he takes, because you couldn't go over the tiles, to check on her. He bends over, sees if she's okay. That's when his brother says, "What the bleep did you do to her?" He says,
Was there anything in the testimony or in any of the literature that was brought to the judge's attention that's in the record that would suggest that you can have one of these episodes and it can be as brief as 2 minutes?
I don't think that was presented. But I would again say, you don't even get to that because there's nothing to put this defense counsel on notice where the defendant is adamantly saying he didn't do anything, denies drug use the day of the murder. None of his family members who now all testify that he has this issue, none of them say anything to her, nor do they claim in their affidavits that they ever told her anything.
So they never told her about him having had any kinds of hallucinatory episodes?
Nope. They never asserted that in their affidavits, that they just told of them. But and the defendant admits, actually, in his affidavit, that none of these were told to the defense counsel prior to trial. So I would suggest, based on the motion judge correctly denied the defendant's second motion for a new trial.
Now, the motion judge wasn't the trial judge, so we don't give him the same deference we would.
Yes, like
trial
on the first
judge.
motion for new trial, where the trial judge was the motion judge and denied that one. Yes, no, he was not the.
Except for credibility findings.
Right.
Yes, you can credit his credibility, which he said he credited Attorney Guzman's, and he did not credit some of the defendants, I believe, and I think he said, he didn't really get into the expert. He said she may have had a viable defense, but he didn't really get to that because he found that the defense counsel was never put on notice. So he really didn't get into the second prong. If there are no further questions, to come over.
Yeah, let me ask you one other question. Okay, it's not ineffective assistance of counsel. What about 33E?
Well, I would, under 33, I think there's overwhelming evidence of the defendant's guilt, and my argument as to the expert's testimony, I think, was greatly undermined due to cross-examination, where she admits, again, that she's never seen this type of spontaneous psychosis before, the defendant's behavior immediately after the murder, and at trial, there was no testimony, all the stressors in his life. I would suggest that would be one of your most stressful moments in your life to be facing first-degree murder trial. He testified he acted fine, there was no issues there. Her conceding that she never talked to anyone other than the defendant and his family members, I think her defense was greatly undermined. So under 33, I would suggest there was overwhelming evidence of the defendant's guilt. And in the interest of justice, I suggest you affirm the defendant's first-degree murder based on extreme atrocity or cruelty.
Thank you.
All right, thank you very much.
Thank you.